Lakewood, Colorado. May 2019. Two men are standing on a public street, filming a DUI traffic stop.
They are not interfering. They are not close. They are doing something 7 federal circuits have said the First Amendment protects.
An officer arrives, stands directly in front of one of their cameras, and shines a flashlight into the lens.
4 years later, a federal appeals court will say he is not immune from being sued for it.
This is what the law actually says about filming police. And the one detail that decides whether you go home or go to jail.
The facts here come from the 10th Circuit and Oppo's published opinion. Not from the video, not from either side and Oppo's account. From the court.
Irizarry is a First Amendment auditor. He and another journalist are recording a DUI stop. Officer Ahmed Yehia arrives and positions himself in front of Irizarry and Oppo's camera, then shines a flashlight directly into it.
Irizarry sues under Section 1983. The district court grants the officer qualified immunity.
The 10th Circuit reverses. Filming police performing their duties in public is protected First Amendment activity, and the court held that right was already clearly established.
He was not asked to leave. He was not accused of interfering. He was filming from a distance, and an officer put a light in his lens. That was the whole fact pattern, and it was enough.
Here is where most rooms stop, and it is where this gets useful.
Courts split this analysis in two. The content of your recording is protected. An officer in Oppo's objection is not a lawful order. He does not get to stop you filming because he does not want to be filmed.
Your position is not protected. He can order you to move. For safety, for scene control. That order you obey.
Filming a traffic stop, protected. Filming it from the middle of a live traffic lane. He can move you, and he should.
Irizarry won because he was recording. The people who lose these cases are almost never losing on the recording.
They are losing on the refusal to move.
There is a case that shows the other side of that line, and it is worth being careful about how we describe it.
In Nevada, a well-known auditor was convicted of obstruction after being accused of getting in an officer in Oppo's way while filming a traffic stop and refusing to back up when asked. He served nearly 4 months.
A district judge later dismissed the conviction as First Amendment protected conduct.
He was ultimately right on the law. He did the time anyway.
Same right. Same amendment. Different outcome. And the variable was not what he was filming.
It was where he stood and whether he moved.
So, what does that mean at the roadside?
Keep the camera visible. In Glick versus Cuniff, the First Circuit found no probable cause for a wiretap arrest partly because the officers could plainly see the phone. Open recording is not secret recording.
If you are told to move, move, and keep filming from there. You lose nothing. The footage is the same. The charge is what you avoided.
25 feet is required in Florida and Tennessee after a warning. Arizona, Indiana, and Louisiana had theirs struck down or blocked. 25 feet is safe anywhere and costs you nothing.
And do not argue the law at the scene. Irizarry was one in front of 3 federal judges, not on a Lakewood street.
Irizarry did not talk his way out of that flashlight.
He filmed, he kept his distance, and he won 4 years later.
That is slower than winning at the curb. It is also the only version that works.
The opinion is public record and it is linked below. Everything we just covered is on a card that lives in your glove box, free files at inkwell.wiki/cards, or we email them when you leave your address. Rest of the story at inkwell.wiki.